Good evening, everyone.
Good evening.
Good evening, Mr. Nordage.
How are you good folks today?
All is well, can't complain.
Good, good. Okay. Yeah. Just okay, I'm just trying to get my okay. All right, just give me a minute. Okay, my apologies, folks. All right. Okay, so we have 3 modules to complete. We have 2 more sessions. And can you hear me?
Yes, we could hear you. I could hear you.
Very
Okay.
much so.
Okay, great. Okay, good. So tonight we're going to look at modules 10 and 12. If we don't get finished 12, we'll finish it up next week. But next week we'll be looking at module 11. Okay, and you'll see on the screen there's a homework assignment, although it's ungraded, on Data Protection Act. So if you go through that section on data protection, I think the page should be just before. I don't know what the number is, but the page should just be before. It talks about the listing of the self-assessment questions. Yeah, so it'll be the page just before the self-assessment questions. Okay, so it says legal and credit risk for property mortgage transactions, homework/class assignment. Okay, so I'll make sure complete that assignment before next class. And at the end of tonight's class, I will send you some more sample exam questions from modules 10 and 12. I'll probably even send 11 on in advance. And then later on, I'll send the, probably Sunday or Monday, I'll send the answers to those questions. So tonight after class, I'll send the PowerPoint presentation and the sample exam questions for modules 10, 11, and 12. Okay, the final exam, I will have 2 sections. Sections 1 will be true and false, which is 25 questions. Section 2 will be multiple choice, which is 25 questions. And that makes up 50% of the total grade for the final exam. Ms. Archer is responsible for the other section, the 3rd section, and she will guide you as to the format of that. Okay, so so let's begin module 10 tonight. Just get my other monitor here going. Okay. So tonight we're going to be looking at duties and liabilities of realtors and contractors. And we'll just do a quick little overview before we actually dwell into the 2 acts that govern real estate transactions in the Bahamas from a real estate agent broker point of view, and also the act that deals with construction contractors in the Bahamas. Okay, so you see it says there are realtors and then in bracket real estate agents. There's a reason for that, and we're going to get into that in a minute when we look at realtors or real estate agents and brokers, in its entirety. But just overall to talk about contracts, it says since the professional relationship between a mortgagor and a realtor, or a mortgagor and a building contractor is based upon terms and conditions of the contracts that he enters into with each of these 2 service providers in the mortgage process, it is important to understand several things. Okay, one of which is the element of a valid contract. The second are remedies regarding breach of contracts. And thirdly, the legal consequences for default in discharging the duties and responsibilities under the contract terms. Now, some of this stuff you may have come across earlier, probably in Module 8, when you're talking about different types of mortgage documents. In particular, your discussion surrounding the sales agreement or agreement for sale. Okay, so so if it's repetitive, it'll really help you overall with your memorization for the final exam, because all of these modules are interconnected. A lot of the information is kind of fluid throughout. And so as we move along, or you may have noted as we have moved along, a lot of it is interconnected, and so you've been able to connect some of the dots. Okay, so those are related contract, the elements of a valid contract, remedies regarding breach of contract, and legal consequences for default in discharging the duties and responsibilities under the contract terms. So what is a contract? So a contract is an agreement between two or more persons or entities that is enforceable by law, provided certain essential elements exist in the formation of that agreement. And what are those essential elements? Well, first of all, they are an offer. So an offer must be made. Acceptance of the offer must be made, and that must be made to the person making the offer. Consideration, it should be for some type of consideration. Usually, there's an exchange. Since we're talking about sales agreements for real estate, the consideration is a sum of money. The intention to create legal relations, that is certainly evident in a sales contract or agreement for sale regarding real estate. It is not, simply like a MOU, a memorandum of understanding, which is not legally binding. But an agreement for sale is a contract, an actual contract, and it's legally binding. And then, of course, there's legal capacity. That concerns a person's age. Are they able legally, by law, have they reached the age where they can enter into a contract? And or whether that person is mentally competent to enter into a contract. Okay, so they're not disqualified by some mental incapacitation. All right. So when we look at contracts, in addition to those essential elements, here are some other things that we want to consider. Okay, and this is taken from your manual. Formation, and these seven points are listed, like I said, in your manual. Determines how and when the contract is created. Validity, the contract must be valid to be enforceable by law. Terms, the parties and provisions are necessary to determine the nature, extent, duties, responsibilities, obligations, and potential legal liabilities. Discharge addresses how the contract can be terminated. And remedies, the remedies outline the legal redress for breach or unintended termination of a contract. 6, limitation, determines when an action can be taken on the contract. And then finally, 7, privity, means that the contract is only enforceable by the parties to the contract and no one else. Okay, so we we talked about the fourth item, discharge. So how do, what, under what circumstances will you discharge or terminate a contract? Well, first of all, by agreement, the parties agree to discharge the contract, and by performance, so just simply by doing what is required, each party doing what is required of them in the contract. So it'll discharge the contract. When it's done, it's done. Breach, a breach of any term or condition in the contract gives the aggrieved party or the innocent party the right to sue and or to treat the contract as having been discharged. And then fourthly, by way of frustration, okay? If an agreement, sorry, if an agreement becomes incapable of being performed due to some event outside the control of the parties, it may then be discharged due to frustration. And for example, the death or incapacity of one of the persons who is to perform an obligation on one side or the other. So in the case of a sales agreement, whether it's the vendor or the purchaser, okay, whether it's the death of one or either of them, okay, or incapacitation of the other. Destruction of the subject matter. So if the let's say there's a building on a property and that was destroyed by a hurricane or some other catastrophe, fire, that could void the contract, and the and frustration can be the means by which it is you escape or you discharge that contract. Okay. So what are some of the remedies? Okay. What are some of the remedies? Well, there are two types of remedies. They're common law equity remedies, and they're equitable remedies for breach of contract. So we're going to look first under common law. Again, we're not going to get into too much detail on these because we want to get into looking at at realtors, real estate agents, and brokers, and the construction contractors legislations. So under common law, you have for damages, action for an agreed sum, and something that's called quantum merit. It's a Latin phrase that means as much as is deserved, or in your text, it says as much as it is worth. It also means what one has earned. It's also a reasonable value for services, or as much as a person deserves. So what quantum merit is, it is taking the reasonable man's approach, right? That under common law, this is as much as the person deserved or deserves in this action. Okay, so again, as much as it is worth, which is in your text, or as much as is deserved, or a reasonable value for services, for the services that should have been rendered. Okay. So let's look a little bit deeper at quantum merit. Okay, in the law of contracts, this is a doctrine by which the law infers a promise to pay a reasonable amount of labor and materials, even in the absence of a specific legally enforceable agreement between the parties. However, the plaintiff must prove 4 basic elements in order to recover under this doctrine. 1, that valuable services were rendered, that the services were rendered to the defendant, that the services were accepted and that the defendant was aware that the plaintiff, in performing the services, expected to be paid by the defendant. Okay. So don't be too concerned about trying to take that information down, because it'll be in the PowerPoint presentation for those who want that information. Okay. So now let's look at under equity or equitable principal remedies, and each of these are granted by court order, okay, or under the direction of a court. So one, specific performance, where a court order directs a party to perform his or her part of the bargain under the contract, and the court will determine the penalty if they don't. So one of which will be that you're flying in the face of the court. So you could be hauled before the judge, and well, the guilty party could be hauled before the judge, and he held in contempt of court, which may end up causing them to be fined or jailed. Okay. An injunction, one of the two parties to the contract can apply to the court to have an injunction which prevents a person from doing something. Okay. A rescission effectively ends the contract and places the parties back in their original position before the contract had even been contemplated or executed. Okay. And then rectification, it corrects the mistake or mistakes in a written document. Okay. And equitable remedies are discretionary by a court and may be made, particularly if damages are not an adequate remedy for the breach. Okay. Now let's just take a step back and look at the agreement for sale in particular. And so if we go back to, I think this might modules 8, and I think probably chapters 1 and 2 talks about transfer of title to land in Bahamian law, which says that the transfer of title to land or real property in the Bahamas is completed by a two-stage process or transaction, one of which is the agreement for sale or the sales agreement or contract for sale. Different names are given by different persons, okay? And the second is the indenture of conveyance. The first one is what we are going to be paying attention to, the agreement for sale, or the contract for sale or the sales agreement. That's what we want to look at in considering contracts, and particularly the sale of real estate and the involvement of real estate agents and brokers. So an agreement or a contract for sale is an agreement which binds the vendor and the purchaser to complete the transaction under specified terms and conditions. These may include, but are not limited to, the purchase price, the deposit amount, the completion date, normally 1 to 3 months from the date of the agreement of sale, the obligation of the vendor to prove good and marketable title. And as you know from what we've covered thus far, this involves an abstract of title showing evidence of good title going back at least 30 years. That is, except, if it was granted by government, that would be an exception. So Crown grant granted by the government would be an exception to this 30-year root of title. Okay. Also, the undertakings by the attorney for the vendor and the purchaser. And lastly, the consequences to the vendor for failure to prove good title, or the purchaser for failure to obtain financing or to complete the transaction within a specified time period. Now, sometimes in the sales agreement, you'll find that the purchaser will try to push for them not to lose, the deposit. Okay, normally the deposit is about 10% of the purchase price, and so you'll find that the vendor will push for there to be either the full for the full 10% to be forfeited if the purchaser is unable to fulfill their obligation, or sometimes 50% of that. On the other hand, you have the purchaser pushing for their lawyer to not have them to forfeit any of the deposit if they are unable to, obtain financing or whatever other reason they are unable to complete. Okay. Some of the other considerations that you may want to or that you may observe in a contract for sale for real estate is that it may be that the purchaser may insist that a proper survey plan be provided by the vendor. They may also insist that boundary markers be set and be in place at the expense of the vendor. This is an area that is lacking quite a bit in the Bahamas based on my experience. Boundary markers, particularly where there is still a vast amounts of undeveloped properties, and so it's difficult to tell where one lot begins when the next one ends. So even in your personal endeavors, you would want to insist, if you're purchasing a property, that boundary markers are set in place. Because you don't want to then have a dispute with your neighbors going forward once you've purchased a property. And so also for your client, you would want your clients who come to you for financing, you'd want to tell them to insert that boundary markers are in place. Okay. That the purchase is subject to a current appraisal report, and usually banks will accept appraisals. Some banks 12 months or less. Some may want something more current, depending on the type of property it is. But generally speaking, an appraisal is good for about 12 months. Okay. And then finally, that the purchaser's deposit will be refunded in full if the purchaser is unable to secure financing. We talked about that a few minutes ago. Okay. The agreement for sale normally provides for specified time period. For example, 14 days from the receipt of the title documents. So once the attorney, the purchaser's attorney has received the title documents, they want to complete within 14 days upon receipt of those title documents. Okay, and so requisitions of title will be made by the purchaser's attorney after investigating title, and we looked at those requisitions previous module. Okay. The purchaser attorney may raise questions on the requisite government and subdivision approvals. That is depending on whether there's a new subdivision. They may make requisitions on understanding property tax assessments and utilities. They may make requisitions on the survey of the property and any pertinent easements and rights of way and or restrictive covenants. Okay. A lot of the subdivisions nowadays are planned. So someone has their mic open and I'm getting some feedback from it. If you close your mic, please. Okay, thank you. Okay, so we were saying the purchase attorney may raise requisitions concerning government and subdivision approvals, outstanding real property tax assessments and utilities, survey of the property and any pertinent easements, right of way and or restrictive covenants. And I was saying most of our subdivisions are better planned now, and so a lot of them contain some restrictive covenants. Um, and so, you know, like no livestock, you can't be using it for commercial purposes, which means like no heavy duty tractors and trucks being put on the property. And of course, if there is a condominium complex, you definitely will have some restrictive covenants based on, um, uh, you know, uh, who is allowed, how many vehicles, whether you can, they normally would not allow you to even change your motor oil on the premises, etc. Okay, so those are important items for a purchase attorney to look at. So upon the requisitions of title being satisfactorily answered, the purchaser's attorney will prepare a report or opinion on title for the purchaser and or the relevant lending institution. And when we looked at the mortgage lending process, this is one of those steps in the process. You will get a opinion on title. It might be on your firm's standard form opinion of title form, but the attorney will also include in their covering letter an opinion of title. So an opinion of title will be contained in the letter, as well as on your form of opinion of title, if you have such a form at your institution. All right. Now, normally the agreement or contract for sale is a standardized format, and I've seen two basic versions. One, which is done by realtors. Realtors have a standard form, and what they do is they just plug in. It's almost like an Excel type form, and you fill in the blanks. The purchaser's name, the vendor's name, the consideration amount, the location of the property, and some other details, addresses, et cetera, et cetera. And then there is a format, a more legal format that lawyers typically like to do. And again, that's a standardized form, but it's more in the form of a legal document as opposed to the cut and paste kind of format that you would have by the realtors. But either form is acceptable. Okay. So again, there are normally two types that I've seen: the standardized one used by realtors or real estate firms, I should say, and one generated by law firms. The agreement or contract for sale, needless to say, is executed by the vendor, who is the seller, and the purchaser, who's the buyer, and it is witnessed. This document is not recorded in the registry of records. However, the second document involved in the transfer of property, that is the conveyance. As you know, the conveyance is actually recorded in the registry of records. Okay. And of course, the agreement for sale must not be an illegal contract or a voidable contract. And again, one of those things that we looked at is, for example, if we find that the person is not of legal age, or there's some fraud being contemplated in the contract. So you find that the person is not actually the owner. of the property that they're purporting to sell. So those are two examples of illegal or avoidable contracts. Okay. So now let's turn our attention to the legislation one dealing with real estate agents and brokers.
Excuse me, Mr. Norris.
And
Can I ask a
Sure.
question, please?
sure, go ahead.
With the agreement for sale, based on my work, at one time, an attorney did lodge the agreement for sale for recording, and the court at the end of the day held that the one, although he should not have, they went and they told the company, you have to give that person the property because it was lodged for recording. That's what they used. Now, in my case now, I have a conveyance agreement for sale out there, although it has a time period. The client is claiming that they don't want the property anymore. But my thing is, if I have an agreement for sale out there, there's no evidence that that client rescinded the offer. Shouldn't it be me to send a letter with rescinding the offer to that individual and just mail it to cover myself?
Okay.
Attorney
Repeat that last part for me.
to cover me instead of me selling, because I have a seller now for that same property. But
Okay.
we are concerned we issued an executed conveyance to that person's attorney. The person is coming in and say they don't want it anymore. How do I cover myself? Do I just issue a letter rescinding the offer to her to cover me?
Okay, so you were selling a property.
Yeah,
There's an agreement for sale.
yeah.
The conveyance has already been
No, not yet.
it's not been executed.
No,
Okay, so the conveyance has not been executed.
no, sir.
Okay. And the person no longer wishes to the purchaser no longer wishes to pursue it.
Yes,
Okay. And you are also in agreement not to release them.
agreed.
Okay. Alrighty. So what has happened is that you both have agreed by agreement to rescind or to end the contract. Okay.
Yeah,
Now so that part is straightforward. Now the second part is where you're saying, should you send a letter to cover yourself?
yes.
Do you have an attorney and have they advised you as to what to do?
I am my attorney. In practice, we rescind offers to cover ourselves. I work for a government agency.
Okay.
We do this in a normal, everyday thing. Our attorney is the AG office. They have advised us previously that we must rescind offers. But the persons, we have a sales unit now, and they have not done that. And that has been the practice, to rescind the offer. My thing is, they want me to issue another agreement for sale to another client. Should I insist on that rescinded letter?
Yes.
Okay.
Especially if that is if that is your culture and your standard process. Do not deviate from it.
Okay.
Right. And because if the other person, if the purchaser is no longer willing, they should have no difficulty in executing the letter of rescission.
Yeah. Okay, thanks.
Okay.
Yeah.
So, but see, there are things like that, and what I tell you, and anyway, the case with following your policies, your procedures, your guidelines, following legal precedent, following case precedent is always the best way to go. And, cover your behind, particularly in matters like this, you would be well advised to do. A case like this did not actually happen with the Lawrence McKinney case with Bahamas Development Bank. But in that case, for those of you who may have already begun reading it or have already read it, you'll see that there are so many areas where established policies and procedures and precedents, whether by common law or by statute law, or even out of custom, were not followed. And it is unlikely that we'll get a chance to go through that in class, but I will definitely, because you have the worksheet, but I will send the completed worksheet on that if you don't get a chance to go through it at the end of next class. But see, law is so precise, and and in mortgage lending in particular, well, any lending, you need, I use that acronym RAD. Okay, you must be a person who likes to read, a person who pays attention to detail, right, and a person who documents. Those are three tenets that you must adhere to when you're dealing with legal matters, when you're dealing with lending. In fact, in every aspect of your life, on your job, you need to read, what is being said, what is being done, what is required. Okay, attention to detail. Sometimes some people are criticized because they pay attention to detail, but there's some jobs that require that you pay attention to detail. Okay, and then of course document. And in this case, yes, get that letter of rescission and get it acknowledged in this instance. Okay, so the Real Estate Brokers and Salesmen Act of 1995 is the act that we're going to be looking at. But before we get into that, I want to, and I included this in the revision of the manual. Before, it was not included in the manual. But the Bahamas Real Estate Association has made an issue of it, and they actually have a position on it, which you can see on their website. That's highlighted there. And again, it's in your manual. But it says that the Bahamas recognizes U.S. copyright law. The word realtor is a copyrighted trademark of the National Association of Realtors, NAR. NAR has successfully taken their sole right of its use all the way to the U.S. Supreme Court. Any member of an affiliate association, such as BREA, that's Bahamas Real Estate Association, is entitled to join NAR. Then and only then will you have the right to use the word realtor. Unless this applies to you, you're breaking the law when you refer to yourself as a realtor, when you use it in your promotional materials or use it on your website. Okay, so in this, so in our manual, we said realtors and contractors. Okay, but you could put that word realtor in inverted commas because our next update, we will change it from realtor to real estate agent or real estate broker, right? But it says similarly, the Bahamas Real Estate Association licensed agents are welcome to join the Council of Certified Residential Specialists, the CIPS Council, etc. This alone does not give you the right to use these designations. Only if you have completed the coursework and electives, submitted your application, and received written confirmation of achieving your designation can you use any of them. Okay, so to say that you are a realtor, or that you are SIPS certified. I think the Bahamas Real Estate Association, in fact, it is required now that you sit an exam before you are engaged. And hand in glove with that is that they want you to have if you're thinking about becoming a realtor, in addition to taking the exam, you must also have a letter from a real estate firm in the Bahamas saying that they are willing to take you on as a real estate agent, or they have taken you on as a real estate agent, and you must be full time. They're not allowing any part time. Now, some people they go through the ropes and then they end up selling real estate part time and do something else. Well, once you get your license, if you want to sell real estate part time, well, that's up to you. But again, if I do slip and I use the word realtor, it's referring to those people who have the designation. But in the Bahamas, generally speaking, we're talking about real estate agents and real estate brokers. So I just wanted to put that disclaimer out there from the outset. Okay. So real estate agents often act on a contractual basis with vendors or purchasers of property in real estate transactions. And they are paid commissions on the gross price for the sale or purchase of the property. A broker, a real estate broker, is permitted to charge and collect commission on the total cost of a property at a private sale or an auction sale or a foreclosed property sale. And we'll outline those commissions. Real estate agents or brokers, their commissions or fees are typically paid by the vendor in a real estate transaction unless it is otherwise stipulated in the agreement for sale on the gross or gross price, sale price as follows. For vacant land, it's 10%. For non-vacant land, it's 6%. Okay. So in the Bahamas, the real estate agents and brokers are registered and governed by the Real Estate Brokers and Salesmen Act 1995. And basically this outlines 4 areas. The registration process for real estate brokers and salesmen, the regulation of the real estate practice or practices in the Bahamas, professional misconduct and disciplinary action, and fourthly, the requirements in relation to handling real estate transactions. So if you were to download a copy of the Real Estate Agents and the Real Estate Brokers and Salesmen Act 1995, you will see those 4 items in there somewhere. And toward the end of this chapter, I've inserted actually a comparison chart listing the various sections, so that if you're interested, you can go straight to a particular section on this, as well as the Construction Contractors Act of 2016. So what are some of the general duties of a real estate broker or agent? One, there's a duty to follow and act on his client's instructions. And this is piggybacking off your manual. Okay. So the duty to follow and act on his client's instructions, for example, in a timely and responsible manner and in accordance with the terms of any contract between his client and himself. The second is a duty to act in good faith and in the best interest of the client. Thirdly, is a duty to act in a professional manner. Fourthly, a duty to account for all monies paid to and entrusted to him or her. And fifthly, to disclose any conflicts of interest. Okay, so if you are closely related, for example, to anyone who's the purchaser or the seller. You need to disclose. You need to disclose those. Okay. So so apart from getting your commissions, there should not be any other benefit to you to yourself, really and truly. Okay. So any questions on that before we look at the Construction Contractors Act? Okay, let's look at the Construction Contractors Act, 2016. Okay, and you'll begin to see some similarities in some of the sections and some of the the provisions of the act and why they were enacted. Okay, so so first of all, the Construction Contractors Act provides for the registration and licensing of construction contractors, and you'll see how that is almost parallel to the Real Estate Brokers and Salesmen Act. 2, regulation of their conduct and practices. 3, a disciplinary board for complaints against unscrupulous or dishonest contractors. Okay, penalties for infractions. A rating system for the skills for constructing different types of homes or buildings. And 6, provides for a client-builder dispute resolution system which incorporates a mediation and/or arbitration process for the settlement of disputes between clients and their contractors. Have any of you ever had to deal with the mediation board for disputes with contractors and their construction contractors and the clients? Any of you?
No.
No? Okay. I don't know if I haven't heard of any. That doesn't mean that there haven't been any. But one of the things that they're saying here that provides for client 5, a rating system for the skills for constructing different types of homes and buildings. What I saw them do for the different types of contractors, based on their it's based on their skill set, and it's also based on their experience, how long they've been in the business, and it's also based on their educational level. And so they allow people who have basic, have BJCs, PGCSEs, to become licensed, so that it is not very strenuous. But they do have a rating system for the skills for these different levels of contractors who have qualified. So, again, a lot of the onus is on the person contracting these construction contractors to really do a bit of investigation on what type of how they've performed in terms of the quality of work, and also in terms of their ethics, in terms of business dealings. So there are two aspects when you're dealing with contractors, and for that matter, when you're dealing with real estate agents. Although you'll find that because Bahamas Real Estate Association and the Act governing real estate agents has been around a little longer than the Construction Contractors Act, or even the Contractors Association, you'll find that the real estate brokers and agents are a little bit more disciplined, and is a little bit more disciplined in the industry, and it is a little easier to get a resolution through the Bahamas Real Estate Association and or the act itself. The Construction Contractors Act is fairly new, and many parts of it is probably untested to a large degree. One of the things that they on the disciplinary board, includes persons who can be appointed by the minister, but are also comprised of other construction contractors. And one of the things that they try to do is they try to ensure that well, the objective, I should say, is that, let's say someone who's been in the business for 20 years does not have someone sitting who's only been in the construction industry for 5 years making a decision, a disciplinary decision on them. So one of the things, and you can understand, the respect and the protocol that is trying to be followed. So they don't want a junior contractor having to end up making a decision on someone who's more senior. So if you have someone who's more senior, you'll find that the composition of the board would contain persons who are his or her peers, or who have been in the field longer or have more qualifications than the person being brought before the disciplinary board. So there are some areas of the Construction Contractors Act that are very practical and that are very meaningful and do put in checks and balances. The proof, again, would be in the pudding, particularly on the mediation side when there are disputes between a client who has hired a construction contractor and that particular contractor. I think for the most part, people, still battle it out among themselves or get their lawyers involved or, go through the courts. But the Construction Contractors Act does provide a measure of protection, and particularly for contractors who are registered under the Act. Okay, so if you get a contractor who's registered under the Act, there's recourse through this mediation process. However, if the person, is like, you have bush mechanics, and if it's a bush contractor, well, again, it'll be like before the Act actually came into being, the client and the contractor have to battle it out between themselves, get a lawyer involved, and or end up in the courts. Okay. So what are some of the duties, general duties of the construction contractor? Well, first of all, and some of these again are similar to, some of these are similar in nature to that of the real estate broker agent. A duty to follow and act on his client's instructions. And in accordance with the terms of any contract between his client and himself, a duty to act in good faith, a duty to build or construct a dwelling house or building in a safe, secure, and professional manner. I'll come back to that after I've covered point 6. A duty to account for all monies paid to and entrusted to him for the construction of the dwelling house or the building, and to use such monies for the purposes for which they were advanced or appropriated by the client and or his lending institution. I'm going to come back to that as well. 5th, a duty to disclose any conflicts of interest. in the execution of his duties. And lastly, 6, a duty to exercise good workmanship in the construction of a dwelling house, building, dwelling house or building to the standard required by law, regulation, or building code established in the Bahamas. Now, going back to number 3, if you look at number 3 and number 6, you may say that, what's the difference between the two of them? Well, there's a subtle difference in that the duty to build or construct a dwelling house in a safe, secure, and professional manner really relates to industry standards and ethical, and is ethical in its orientation. Okay, so it really results to it relates to your industry standards and ethical standards, whereas 6 is more law oriented. So where 3 may fail, 6 will pull up any slack. Okay. Now going back to 4, point number 4, he said I'll come back to that as well. The duty to account for all monies paid to and entrusted to him for the construction of the dwelling house, and to use such monies for the purposes for which they were advanced or appropriated by the client and or his lending institution. A lot of the problems that arise between a construction contractor and their client has to deal with money. Often as a mortgage lender doing construction loans, you'd find that contractors are not good money managers. And so when money comes from their hands, rather than using that money for that specific project, they use that money and spread it out to other projects. And that is one of the reasons that problems arise. That's another reason that some of them need mobilization monies. They need to come from mobilization monies because they are not using the money properly. Okay, and some of them will use the money to pay off their suppliers, and the accounts of those suppliers may be for more than one client. And so, unfortunately, you have the client whose home is being built. They are suffering because the contractor has used the money to settle his account with a supplier that incorporates several other clients. And so sometimes it may be to the detriment of their project. So for example, if they have a smaller project and another client has a larger project, well, the contractor may then now go and use his available credit to take it up to the hilt to get the supplies to complete or to do the next phase or stage of construction on the other client that has that's going to bring him the more money, that has the bigger contract. Okay, so as a result, now you find that the client with the smaller contract is now at a disadvantage and now having to wait until the contractor now gets money, or they have to now find a way to get mobilization funds or advance funds to the contractor. And if they are have come to a mortgage lender, that's when they'll come to you and they'll say, could we find a way to give some funds to the contractor so they can, get supplies and continue with my project. And so contractors, a lot of them, they are aware, particularly if their client has gone to a lender, that they are going to be putting the lender and the client between a rock and a hard place. But they know that normally that they will prevail because the lender wants the project to continue to go on, because they need the client to get in their house, and they need to convert that loan to a full-fledged mortgage where they're collecting principal and interest. So you may find yourselves as lenders compromised as to what amount do you release. And so sometimes this is where the appraiser or the inspector for the project, the building inspector for the project, would probably be called in and asked for his or her opinion. Based on this next stage that needs to be built, what amount do you think is needed for supplies? Or you may ask the contractor to bring in the listing of the supplies needed and the cost. And so then you may release some funds in stages to the contractor to get the project remobilized and hopefully eventually finished. But again, point number 4 has been a sore point for many people who are building with their contractors. All right. Anyone has any comments or questions on that or any other aspect of this?
I've had 2 very bad experiences with contractors, so I'd rather not comment.
Okay. This is for a client or for yourself?
No, this is
This
me
is personal
personally.
or for client? Oh, okay, all right. And that's understandable because there are a lot of people who do, and you find, in particular, they tend to take advantage of women. But nowadays you find that some women are more demanding and standing their ground more than men, and that's because a lot of women are now being educated. We find some of our lending institutions have workshops, or they have they offer seminars targeting women, not just on wealth management or wealth creation, or not just money management, but also on construction. So they're not plentiful, but you find some lending institutions are doing it or have done it. And I've been a part of 2 lending institutions where they have held such seminars and or workshops. So hopefully, we'll all be more. You're never going to eliminate dealing with unscrupulous people, because the same thing with mechanics and plumbers, carpenters, people who are building cabinets. You have unscrupulous persons. Unfortunately, the field is growing in so many different areas in the country. But hopefully, the Construction Contractors Act, if a contractor is used who is registered with them, there should be some recourse to clients rather than what was happening before. So finally, to close out this session, I'll just bring up on the screen the last item of preparing for module 10. Okay, and it's just showing the similarities between the various sections of Real Estate Brokers and Salesman Act 1995 and the Construction Contractors Act 2016. So you see that they're sort of very similar, and most acts they begin with a preliminary section talking about a short title interpretation. Part 2 normally says what the act is all about. Toward the end, they'll have like a miscellaneous section and stuff. But you can see that they pretty much mirror each other. The Construction Contractors Act, when it gets to registration qualifications, certificate of registration, licensing of contractors, financial provisions, they actually have that in 4 sections, whereas on the Real Estate Brokers Act, they have it in 1, so it's part 3 for the Real Estate Brokers and Salesmen Act, and it's parts 3, 4, 5, and 8 for the Construction Contractors Act. But they pretty much mirror each other, okay? And at the beginning of each act, the sections are outlined. So if you need to go to a specific section of any act, not just these 2, but any act, you can just look at, it's almost like a table of contents. Look at it, goes straight to that section, scroll down to that particular section. Okay, so, all right. I just want to, if you would go with me to the self-assessment questions. They're just 2 typos I want to take care of. So go to the self-assessment questions page, question 6. That should read, what is the real estate commission fee for developed property? Okay, that R should be a D. So what is the real estate commission fee for developed property? And then question 10. What are the general duties of a contractor under principles of contract? Tort, the T is missing, T-O-R-T, tort, agency and equity. And those are the only 2. Okay. So that ends module 10. Let's look at module 12. Let's go to module 12. We'll come back to module 11 next week. So module 12, ethics and risk management. What I've done is I've segmented this into 3 basic compartments, okay? The first being ethics, the second being corporate governance, and the third being risk management, okay? So under ethics, we'll be looking at definition, we'll be looking at ethical behavior, ethical decision-making, codes of conduct, and we won't get any detail into the scandals. But if you need further information on any of the scandals, I'll be happy to send them to you, particularly the 2 that I mentioned here, the Barclays LIBOR and the Wells Fargo ghost account scandal. Okay. Okay. Some of this information will be indicated on the screen. That is not a part of your manual or your text, and you're not required to know that for exam purposes. It's just included to enhance our session and your understanding and knowledge if as necessary. So first of all, let's look at the definition of ethics. It says here that ethics takes into consideration what is right and wrong and good and bad conduct, either in situations require some choice, action, or decision-making, either individually or in organizations and society. Okay, so it affects us individually, it affects us in organizations, and broadly in society on a whole. Okay. Ethical behavior is based on the following principles of fairness, and again, this is in your text, um, fairness, integrity, objectivity, transparency, accountability, and professional responsibility. How is ethical behavior derived? Well, we all had our genesis in a family, okay? So, and a lot of those all of our families have been in uh, some sort of village or community. And so initially from birth, we are impacted by our parents or guardians and our family. And then that extends outward to our neighborhood, our neighbors, also our schools, the nursery schools we attend, the primary schools, the secondary schools. And then eventually, some of us go off to university. So, so the first impact is societal culture and norms. They impact ethical behavior. And as we move from our family into the community, church, civic groups, community, schools, college, we come back home, we interact in business, either the company that we work for and our interaction with other businesses with which we have interactions with. We are impacted we are impacted by the various business cultures that exist and industry practices. Okay, and so sometimes even in the various industries, private, government, we find the different types of culture. Okay, and even within the private sector, there are different cultures and practices, and the same thing with government. Okay, and as we move along the spectrum, some of us will move from just regular businesses and industry practices, even into corporate cultures and expectations. So these are the larger multinational companies, those that come to the Bahamas in particular, and they impact our own culture here in the Bahamas. So they bring their own cultures and expectations. So we have basically three tiers. From the time we're born, go to school, we begin working, and we also influence, because we are a global network. We're impacted by international corporations as well. And so those three elements will help us to form what is called our personal moral philosophy and ethical behavior. So even though a brother and sister, for example, or two sisters, or anyway, siblings may come from the same household, from the same neighborhood, attended the same nursery, elementary school, primary school, secondary school, even going to the same college, right? They may end up working, for government or working in the private sector. You will find that they will not have an identical personal moral philosophy and ethical behavior. There's going to be slight differences. There may be even major differences. Okay, they may be totally opposite. Okay, but what we do is we take all of those experiences and all of those lessons that we have learned and all of those exposures. We take all of those, and again, we develop our personal moral philosophy and ethical behavior. And that is how we function in business, back in our homes. We interact with international corporations, and we interact even if we go abroad how we interact with other cultures and other organizations abroad. Okay, so that is how ethical behavior um, is derived, in pretty much in a nutshell. Okay, so what is the impact of culture on norms and values? Sorry, the impact of culture, that is norms and values, on ethics. Okay, um, basically you'll find that a country's governance system impacts how ethics, uh, well, let me say, impacts the ethics of a country, of an organization. And it is whether or not that country's governance system is rule-based or whether it's relationship-based. Normally, you'll find countries whose governance system is rule-based are more of the developed countries. And those who are third world or developing countries, which they say we are part of, are more relationship based. Okay, it's like who you know, and because we're so small, everyone knows each other. So it's well, I know this person, I can rely on that person, I trust that person, or I don't trust that person. Okay, whereas in the more developed countries, um, Switzerland, the United Kingdom, America, Canada, it is more rule based. Although even in those, even in those countries, they also have relationship-based um, uh, governance systems, okay, or ethical systems. So for example, you may have heard of in Washington D.C. with the lobbyists, okay, and a lot of talk has been. Um, we've heard a lot of talk in the last 4 years about draining the swamp. And that is because the swamp is based on relationships, okay? And so you'll have people going to congressmen and going to senators who they know, or they have the lobbyists who are paid for their services to get congressmen, excuse me, or senators to pass legislation that favors their business or their businesses, okay? So that is kind of like a relationship-based governance system even within an overall rule-based uh, governance system. Okay, so so the lines the lines can be blurred, but generally speaking, the smaller countries like the Bahamas and Caribbean countries, we are relationship based, and countries like the UK, Switzerland, France, United States are more rule-based. Also, there are business goals versus other interest groups. Okay, so and that so for example, you may have uh, you know again you have these groups on the outside. I'm trying to remember the name of the group. But mainly it'll be environmentalists who are lobbying. So, for example, what happened in Freeport with the oil business, you have people saying, "No, we don't want that oil uh, refinery in our area," okay, because it's gonna, we've seen how it's affected us negatively in the past. We've gotten sick, people have gotten cancer, okay, from some of the seepage of the oil in the water system, the water table, and the water system. So you'll have other interest groups lobbying um, their causes, and of course you have the businesses saying, well, there's money to be made. Um, industrial accidents are few in between. Blah 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 blah. So so we see the impact of culture in on two fronts, based on the country's governance system and also based on business goals versus the interests of uh, groups, interest groups out there. Now, So that we've looked at how ethical behavior is derived. We've looked at the impact of culture on ethics. Let's see. Let's look at a survey. A survey that was done back in 2004. So this is a survey of some executives from 111 national and multinational companies. And 70% of those executives from those 111 companies, 70% of them said that they bend the rules. And among the three most common reasons are that organizational performance required it. So 74%. Next, the rules were ambiguous or out of date. There was 70% of those. And surprisingly, pressure from others and everyone does it, 47%. I thought that they would be a little higher. But I guess if they were to do a survey now, it might be different, might be higher nowadays. Okay, but pressure from others and everyone does it was certainly a factor. Okay, so the three top: organizational performance required it, rules were ambiguous or out of date, pressure from others and everyone does it. And a lot of us can identify what organizational performance requires it because we have a lot of our goals, we have our we have certain requirements that we have to meet, either in loan growth or if you're in delinquency, you have to get your delinquency numbers down. If you're in deposits, you got to get the deposits up. So in any area of the financial institution, we find ourselves, we have these goals and these expectations that must be met. If not, our performance reviews will reflect how poorly or how well we fared. And so organizational performance required is not surprising that it is as high as 74%, and probably even higher if more people would be actually honest about it. So ethical decision making may be stakeholder based. It may be consequentially based from the consequential perspective, which is outlined in your, just very briefly in your manual, or the absolute perspective. Those are two perspectives. The consequentialist perspective, they say they actually focus on the cost / benefit effects and consequences of a decision, whereas the absolute principle perspective focuses on aligning action with universal ethical principles. Okay, or it can be systems based, where the decision making is carried out through a series of probing questions on the causes or drivers of the situation that you are faced with. Okay, so those are four main ethical decision making aspects. It could become from a stakeholder-based, consequentialist theory perspective, or an absolute theory perspective, or it can be systems-based perspective. Now there are, whether they're written or unwritten, you have organizations that have codes of conduct or codes of ethics. So whatever decision-making model, and that is whether it's stakeholder-based, consequential, absolute, or systems-based, whichever one of those models that your organization has chosen, they must operate and conduct itself within the guidelines of its code of conduct or ethics or moral standards. And the reason for this is to ensure fair and just treatment of employees, to ensure fair and just treatment of clients as well. Okay. So there are, the next slide will show us a few examples. For example, the American Medical Association has principles of medical ethics. I won't do those for the sake of time. But the Chartered Banker Institute has a code of professional conduct, and the Chartered Institute for Securities and Investment, they also have a code of ethics. The Rotary Club, for example, has their 4-rule test. So, you know, a lot of these organizations, whether they are an established business, or whether they're a charitable organization, or whether they are a professional organization, they have their code of ethics, or they call them a code of conduct. So code of conduct, code of ethics, same thing. Okay, it's a guiding post for the organization in how it expects its employees to perform and act. Okay. So there are some international scandals and financial controversies that have highlighted the need for individuals and organizations to promote and value ethical behavior throughout the organization, and also have caused the rise to hold persons accountable who breach ethical standards of professional conduct and behavior. Some of those scandals are listed here and also in your text. There's Parmalat, the WorldCom, Enron, Tyco. A lot of people know about the WorldCom and the Enron, particularly the Enron, and the US subprime mortgage crisis that triggered the 2008 recession. And then two here that they recommend you look at, the Barclays LIBOR scandal and the Wells Fargo ghost account scandal. I won't get into those, and you won't need to know about those for the details of those for exam purposes. But it makes interesting reading to see how Barclays dealt with the interest rates and the LIBOR interest rates, and Wells Fargo, how they dealt with creating these ghost accounts, pretty much because of fine print and customers not being aware of what they were signing, and opening accounts in customers' names without their knowledge. So those are two that would be interesting to read relating to this particular course of study. The others as well, you know, like I said, WorldCom, Enron, the US subprime mortgage crisis. Those three also three good ones to look at. Okay. There's a website there that you can look at the LIBOR scandal, the LIBOR and Barclays Bank. And what I can do is I think I have a PDF file on the Wells Fargo ghost account scandal. I can email that, and I email the PowerPoint presentation for those who may be interested in reading that. Okay. So, mortgage professionals and their involvement, specifically as it relates to well, from the whole mortgage process, from beginning to end. Mortgage professionals are particularly encouraged to evaluate practices in mortgage lending that may be seen as unethical or, in some cases, predatory and even illegal in the sales-driven banking culture, where commissions, bonuses, promotions, and even job security is based upon performance measures that may motivate persons to act unethically. I alluded to that earlier, a few minutes ago. For example, booking mortgage loans before completion, being paid a cut of the mortgage proceeds for approving transactions, failing to explain pertinent or important bank procedures or requirements to a client, etc. Right? So the conundrum that is faced by mortgage lenders or loan officers is because of those pressures. It's sales driven. It affects your commissions, your bonuses, your job security, promotions. Again, if you don't perform, it's going to be reflected in your appraisal, your performance appraisal, and that affects those commissions, bonuses, promotions, job securities. So some people succumb, and as a result, they get involved with kickbacks, information manipulation, booking incomplete loans. So doing things like omitting information on loan applications. So, for example, to make the debt service ratios look good, if the customer has more than one credit card, they may only list one of the credit cards, or they may not list the credit card. Or instead of listing the customer's rent, when they pay rent, they may say, oh, the customer lives with family or lives with a parent or something like that, or a sibling, and they don't pay rent. So sometimes we will do some information fraud or manipulation. But there's also another way in which customers are disadvantaged, and that is where a lender who doesn't necessarily want to lend a particular client or to a particular class or segment of the community, or to a particular individual or individuals. And so what they'll do is they'll set terms and conditions that you kind of figure that the person who has applied for the mortgage that they won't accept. So you may, set interest rates, a little high. You may say that they have to put in more equity than is normal. And I've seen this done in at least 2 instances. And in both instances, it was done to people who are in a same-sex relationship. Okay, and this is where you have to be careful with your personal ethics and your personal beliefs and the policies and procedures and guidelines of your financial institution. That if, because of your religious beliefs or your Christian beliefs, you don't believe that 2 men or 2 women should be getting married or should be a family or husband and wife. If your financial institution allows such allows loans to be given to people in those categories. So, for example, they may not approach you as a same-sex couple. They may approach you saying that they are doing an investment. Okay, so they want to buy the house as an investment, or the apartment complex as an investment, or the condominium as an investment. Okay, if your organization, your lending company, allows 2 males or 2 females to borrow, then you're gonna have to separate your your personal ethics or Christian quote unquote beliefs from that of the company. The extent to which you cannot do that, then you may have to hand it off to someone else if you're that conflicted. Okay, but the customer should not be disadvantaged because of your personal beliefs or your personal ethics. Okay, like I said, I've been involved in 2 organizations where the lending conditions were set so as to discourage the people. They didn't want to come out right and decline the loan, saying we can't, because on what basis were they going to decline it? Okay, if the policy did not specifically address certain things. Okay, so in one instance, the duo, the couple, accepted. They accepted the conditions, and in the other instance, the couple did not accept the conditions. So there were 2 instances that I was uh, privy to, in organizations I was a part of, where it happened. Okay, and some of you who do not know me, I come from a very strict religious or Christian background, and so when I was asked about my superior, when my superior officer and I were discussing it, they were surprised that I didn't have a conflict because of my religious beliefs, and I said, no, because if you approach it that they are doing it as an investment, what does our policy say? Does our policy say, husband and wife only? Does it say, no, there's no parent-child relationship? Does it say no to 2 men coming or 2 women coming? And so when they approached us and they said, we are doing it as an investment, you can't turn it down despite your personal beliefs. But in both instances, my superior officers, while they were not as quote religious as I was or as Christian as I was, they were very homophobic. Okay, and so they had a personal dislike for people with that disposition. And so they allowed that, and the fact that they had the position and the power to do those kind of things, to alter and increase, requirements like increase interest rate, increase the amount of contribution, the down payment for the mortgage, shorten the term period, stuff like that. But the fact that they were in that position, they had no problems doing it, but I, from an ethical business point of view, I had a problem with it. Okay, because the company, or the 2 companies I worked for, did not outlaw it. Okay, I don't know if anyone has any comments or experiences they want to share, or you may have a differing opinion. Anyone?
I had a situation where I dealt with a couple that came in for pre-qualification on a mortgage. And so they didn't come out and disclose to me their situation. They basically wanted to understand what they could qualify for separately, and then they eased in as they got more comfortable and said, what if we decide to do this as an investment together? But we just went through the standard requirements. No judgment was passed. I tried to keep a straight face. I knew one of the parties personally. And so I just tried to remain professional and give them the options that they needed.
Okay. And that was wise, because you see, the thing about it is, if they get wind that you're discriminating against them, and they go up, the hierarchy chain, you could find yourself you could find yourself in a sticky situation. So in these two instances, which are two different financial organizations, different times, it didn't get to the point where it went higher to, say, head office or an international office or the board of directors or whatever it is. But it for my superior officer, it could have ended badly, particularly in the case where, well, actually either one, because you know the case where the persons accepted it, they were from well-to-do families, and so you know so putting more money in wasn't an issue for them. They had the backing of their family, and in fact, the mortgage was paid off well before the time frame. So even though the time frame was shortened from, say, 20 years to 15 years, in less than 5 years, they paid it off. Okay, because they understood at that higher interest rate they'd be paying more, and so so coming from well-to-do families, they had business heads, and two, they probably understood what was happening, that they were being, quote unquote, victimized because of their relationship, and so they figured, well, this isn't the time to rock the boat. Now, mind you, this is like 20 or so years ago. Okay, if that same scenario today, because of more advocacy, chances are, there'll be some outcry, probably on social media. They posted on social media, I went to XYZ bank and they turned me down because they said I'm gay, blah 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 blah, so nowadays, 25 years later, I'm sure, it won't be as it won't be the same. There more than likely would be a public outcry. They would bring it to the public, and it could cause reputational risk damage to the organization and embarrassment. And if they're not careful, they may have persons who are like-minded or sympathetic to them, who have lots of money in their financial institution, and then they could find that they have a drain of a source of funding. People close their deposit accounts and whatnot, move their other business elsewhere. So reputation is important, and it's also important, getting back to this point, that you follow what the policies and the procedures and the guidelines are, where you have your personal ethics and standards. You have to be guided overall by the companies. Now, where the company wants you to manipulate and whatever it is, and it is immoral and it is illegal, right? Then you have a choice to make, whether you stay there and grit it, or you look elsewhere and eventually move on. Okay, but as long as it is legal and it is ethically legal, I should want to add. So because sometimes something might be ethical and not legal, but as long as it is legal and it is ethical it's not immoral. You need to follow the guidelines of your organization. Okay. Now there'll be very few organizations that'll want you to do crookedness or manipulation. So let me just add that. Okay. But thank you for sharing that with us. Anyone else who wants to share? Before I move to the next slide. Okay, well, let's move to the next slide, which is called the Ethical Leaders Decision Tree. This was put out by Harvard Business School. Okay, and and it kind of gives you it's a tool to help you to make a decision. So what's the right thing to do? We start from the far left. Is the proposed action legal? If it's not legal, don't do it. If it is legal, yes, you go to the next box. Does it maximize shareholder value? If the answer is no, you go to that box that says, would it be ethical not to take the action? Okay, and even that box has a yes or no. So then if it's no, it says do it, but disclose the effect of the action to shareholders. Or yes, don't do it. Now we go back to, does it maximize shareholder value? Yes, that has a box. Is it ethical? Okay, if it is no, don't do it. If it is yes, do it. So to me, I think that was kind of one of the better models, ethical decision making models that I've come across. There may be something else out there, but this is one of the better ones that I've seen, and I thought I would share it with you, folks. Okay. So we've covered on a bit about ethics and sort of corporate governance, and okay. All right, it looks like I've missed something here. Okay. Okay. Look like my corporate governance notes have been deleted by error. Okay. Alrighty. My corporate governance notes have been somehow I deleted them. Okay. With corporate governance, let's look at the OECD's definition of corporate governance in your text. So let's go to that page, highlighted corporate governance. The Organization for Economic Cooperation and Development defines corporate governance as a set of relationships between a company's management, its board, its shareholders, and other stakeholders. Corporate governance also provides the structures through which the objectives of the company are set, and the means of obtaining those objectives and monitoring performance are determined. What are the reasons for corporate governance? Well, corporate governance should provide proper incentives for the board and management to pursue objectives that are in the interest of the company and shareholders, and should facilitate effective monitoring, thereby encouraging firms to use resources more efficiently. Also, corporate governance provides the critical underpinning or pinning for the relationships, responsibilities, and reporting lines for the board of directors, senior management, shareholders, employees, clients, and other shareholders of an organization. Let's skip the stakeholders right now. and look at the bottom. At the center of the requirement of good corporate governance are the proper understanding, appreciation, and practice of the high standard of duty, skill, and care expected of directors and senior management, and the prudent discharge of their duties and responsibilities, both internally and externally, within the ambit of applicable law, local regulations, and international standards of best practice. So let's go back to the stakeholders. Who are the stakeholders? The stakeholders are shareholders, employees, investors, service providers, suppliers, and the community. Let's go to the top of the next page. A comprehensive understanding of their responsibilities and accountabilities by the board of directors and senior management, and clear and consistent communication of the process of good corporate governance within an organization or to such stakeholders are paramount to effectiveness of any corporate governance regime. Okay, so again, the stakeholders that they're referring to are the shareholders, the employees, the investors, the service providers, the suppliers, and the community. And there's two more points. An integral part of the mandate of directors and senior management is the identification, measurement, monitoring, control, and minimization of various risks to an organization. Such measurable criteria as the accuracy, reliability, timeliness, relevancy, and thoroughness of an organization's risk management system, and the frequency, effectiveness, and productivity with which each director and senior management are able to obtain information regarding these measurements are critical to the soundness of any corporate governance program and its attendance compliance measurements. If we look at the Central Bank of the Bahamas guidelines on corporate governance, we'll see the annual certification of the board, and there are 3 points that I wish to highlight. Okay, so in the first paragraph under the section, the Central Bank of the Bahamas guidelines on corporate governance, it says the board of directors of licensees, that would be banks and trust companies of the Bahamas, is required on an annual basis within 120 days. So please note the filing time, okay? So within 120 days of the companies or the licensees' calendar year, they must certify in writing to the inspector of banks and trust companies that upon the advice and assistance of management, it has assessed and documented the effectiveness of the licensee's corporate governance process and its success in meeting the organization's overall objectives. So the first thing it must do is it must state that it has assessed and documented the effectiveness of the licensee's corporate governance process and its success in meeting the organization's overall objective. Secondly, and in the next paragraph, this is where we find this, it must also report any material deficiencies, weaknesses, and problems that they may have identified in their risk management assessment and monitoring during the year, along with any action plans and timetables for remedial action. So that's the second thing. The third thing is in the third paragraph, that they must document annually whether their corporate governance process has been implemented effectively and has successfully enabled them to achieve their overall business goals and objectives. So there are 3 things that they must do, the board of directors must do in writing within 120 days of the end of its calendar year, addressed to the inspector of banks and trust companies. Okay, and they are found in the first paragraph, the second paragraph, and the third paragraph under the Central Bank of the Bahamas guidelines on corporate governance. The annual review and assessment must be done by external auditor of the methodology used. And that information is contained in the last paragraph on that page. Okay, so it says, an external auditor must be engaged by the licensee to annually review and assess the methodology followed by the board of directors in analyzing and monitoring the organization's corporate governance process. And the auditor must report directly to the board of directors and the inspector of banks and trust companies on any discrepancies within the board's risk management assessment. Okay. Any questions on that before we look at risk or risk management? Okay, again, I apologize for the omission of those slides.
Mr. Nordich, question. To what extent any of this relate to the Securities Commission? Is that only limited to government agencies?
This is related to all of those licensees under the banks and trust companies. So you know, your banks like, you know, Fidelity, Commonwealth Bank, etc., Bank of the Bahamas. You also now have your credit unions, because they're now under the ambit of the Central Bank of the Bahamas. Okay, and trust companies who do lending.
Okay, so now broader scope. Thank you,
Yeah,
sir.
no problem. You're welcome. Okay, so so that's it for corporate governance. When I send the PowerPoint presentation to you, I'll try to reinsert those. I don't know where they disappeared to, but I'll reinsert those when I send it. Okay, risk management definition, and then we look at two aspects of risk. It's management and risk intelligence. So risk management and risk intelligence. So risk, a very short definition, anything that poses a threat to an organization. And whenever an organization has objectives to reach or goals to meet, they will risk resources in order to reach those goals, to reach those objectives, or to meet those goals. What is risk intelligence? Risk management. Let's look at risk management first. Risk management is a process of dealing with these threats. It is a tool that allows these risks to be managed in an environment which is uncertain. Risk intelligence. Risk intelligence is the capacity to learn about risk from experience and use that knowledge to solve problems which require an understanding of risk. It also has been defined as a special kind of intelligence for thinking about risk and uncertainty and the ability to estimate probabilities accurately. And there's a kind of like science that goes on with risk intelligence, which is probably a mini course all by itself. So risk management responsibility, there are 3 levels. Let's look at those 3 levels. Risk governance, risk infrastructure, and risk ownership. And if you want to, you can flip over to the Deloitte chart on the top of the other page, the little triangle or pyramid. Okay, and you'll see that that's segmented into 3. The top being risk governance, the middle being risk infrastructure, and the third being risk ownership. Okay, and we're gonna combine some of these notes right now. So let's look at each of them separately: risk governance, risk infrastructure, and risk ownership. So risk governance, again, keeping an eye on that pyramid, that triangle there. Risk governance is the strategic level. That's your strategic level. And that's where strategic decision making, and risk oversight is conducted and is led by the board of directors. Okay, so in our pyramid, you see risk governance, board of directors. Okay, so the strategic decision making and risk oversight is led by the board of directors, and the risk governance or board of directors, they direct and define acceptable levels of risk. They monitor strategic alignment, and they set overall risk expectations. Risk infrastructure. This is the second tier, the middle tier. It is the management level, whereas the first was the strategic level. This one is your management level, and it involves designing, implementing, maintaining an effective risk management program led by the executive management team. It is comprised of the 3 pillars of people, process, and technology, and forms the essential link between risk governance and risk ownership. That word should be link. Okay. Risk ownership, the third level. While it's at the bottom, that doesn't mean it is less essential or less important. In fact, if we go back and we look at the third point for risk infrastructure, comprised of the 3 pillars of people, process, and technology. People are important. Okay, so and that is all levels, especially when you get to the operational level. Okay, so how we treat our line staff who are, in the, who are at the forefront on every day, dealing with clients, dealing with various issues, is very important. So even though it's on the bottom here of this triangle or pyramid, it does not lessen its importance. So again, we say risk ownership is the operational level, concerned with identifying, measuring, monitoring, and reporting on specific risks, led by business units and functions. Without that feedback, a company will fall and fail. Okay, so this is a very essential element or level in the overall risk management responsibility. It is relied upon by risk governance to execute risk intelligence. It responds to risks in accordance with risk governance mandates. Okay. And again, if you look at the pyramid, I don't think it's too clear in your books, in your text, but it's a little clearer here. So risk governance, the board of directors, again, that's your strategic level. Risk infrastructure and oversight, that's the executive management team, that's your management level. And then thirdly, risk ownership, that's your business units and supporting functions, that's your operational level. Okay. So type of risks, there are 4 key areas. The strategic risks, operational risks, financial risks, and compliance risks. Okay. strategic risks, and these are outlined in your manual. Strategic risks are risks both to and of an organization's strategic objectives. Operational risks are major risks that affect the organization's ability to execute the strategic plan. Financial risks are risks in areas including financial reporting, valuation, market, liquidity, and credit risks. And then fourthly, compliance risks. These are risks related to legal and regulatory compliance. Generally, and depending upon an individual's business size and activities, clientele, and geographic location, an organization may also experience the following types of risks during its lifetime, and that is compliance, credit, fiduciary, legal, market, operational, regulatory, reputation, or sometimes called reputational risk, and technology risk. The majority of those, there are definitions for all of those except 3 of them, I think, in module 11. So in module 11, toward the end of module 11, you'll find some definitions of compliance, credit, legal, operational, regulatory, and reputation risk. You won't find the fiduciary risk, market risk, and technology risk among those definitions. But I will, again, I'll send those to you. I'll include them in the PowerPoint presentation that I'll send to you, because it's good to have those on hand. Right. So the risk management process is basically a four-stage process, and it doesn't just necessarily follow stage 1, stage 2, stage 3, stage 4. It's almost like a cycle. Okay, and you have to review this cycle constantly. But it starts with risk identification and assessment. Okay, so identify the risk and make an assessment of that risk. Risk mitigation. What can we do to minimize the risk? Because you're not going to fully eliminate the risk, but you can at least soften the blow. Then there's risk monitoring, implementing management information systems, and keeping up to date with changes to the risk profile through changes to the business and/or to any threats to the business. And then, of course, documentation, designing and implementing policies and procedures that cover any of those 3: risk identification, assessment, 2: risk mitigation or risk monitoring. Okay, and deliver effective accountability from the board and senior management all the way down. Okay, and as necessary, you may find you need to review again, complete a new assessment of the risk, or there may be a new risk that you identify. And so then you have to do that process again, follow that cycle. How do you mitigate against that risk? We monitor that risk. And of course, we have to do some documentation, right? There are some important questions to ask yourselves, and I'll leave that to you to look at those. I think there's 13 questions, beginning with what is the important organization's philosophy towards financial risks, ending with how much information can a shareholder or stakeholder obtain regarding the financial risks of the organization. Okay. Any questions on that before we kind of wrap up? for tonight? Any questions, any comments? Excuse me. Okay, no questions, no comments?
No, no questions.
Okay.
Or no,
Um,
thank you.
No, no questions.
what I'm gonna do is, let me just, I'm just gonna run quickly through Lawrence McKinney Farmers Development Bank case. Again, I'll follow up. I'll forward the completed worksheet. But just to kind of give you some food for thought about that case, because those of you who are involved in mortgage lending, it is a, there's also another Bahamian case. I think Joan Davis rule or something like that. I think Joan Davis and Finco, I think it is. But this one, Lawrence McKinney and Bahamas Development Bank, 1997, is a is one that so many aspects of what we have from module 1 up to now, it is touched on just about almost every module, everything that we have talked about. When you've done with all of your studying and whatnot, read this case, because it's gonna help you on the job, on some of the pitfalls, what to avoid, what to look for. Okay, so the case study, again, Lawrence McKinney versus Bahamas Development Bank et al., 1997. Looking at the case, we want to look at the historical background information about the case. This is a case where Lawrence McKinney went to the Bahamas Development Bank. He borrowed some money. He put up the two properties, one on which the business was and one on which was his residence as well. And he sold the business to two people who were renting from him at some point in time. And he moved to one of the family islands. And so what ended up happening was, a series of Murphy Law catastrophes. And if you know anything about Murphy Law, it says, one of the laws is, if anything can go wrong, it will go wrong, right, or something to that effect. Okay, so there were a lot of missteps by the bank, by the Bahamas Development Bank, that ended up with this case. And in fact, this case went on for years and years and years, because Mr. McKinney kept filing and refiling and refiling. And so when you read through the case, you'll see that they'll be saying, the resubmission of this and the refiling, and it'll refer to it. So so there are four aspects of this case: historical background information about the case, general lessons to learn, specific lessons to be learned, and whether there was a surplus or shortfall, from the sale of his properties, because that's the question at the end of the day. Okay, so again, the historical background of the case, refer to the actual case, but some general lessons to be learned. Point number 4, Always follow procedures, policies, and guidelines. And the information I gave you on RAD, for being radical, read. So the banker-customer relationship, the general duties and rights of the bank. B, the general duties and rights of the customer. The duties and rights and liabilities of the bank as mortgagee. A, pay attention to detail. And D, document. Okay, so that's RAD. So that's some general lessons to learn, specific lessons to be learned. Again, we come back to always follow procedures, policies, and guidelines, just like in the general law. Okay, always follow procedures, policies, and guidelines. Secondly, always follow laws and precedents, any case laws that you have, okay? And also follow any established customs that banks have in dealing with customers. Okay. The issuance of demand letters. Make sure it's properly executed and issued with respect to the date, the amounts claimed, the current address. The notice to redeem is first of all accurate. That is in accordance with the mortgage document and precedent. And B, it is observed, that is allowed the time to run its full course. One of the things that you'll find in this case is that the letters of demand didn't correspond with some of the actions of the bank, the amounts claimed, the current address. They sent it to an address in Nassau when Mr. McKinney had informed them that he had moved to Acklands, and they say no, they didn't have any notice of it. But when they checked their records, they saw that there was a letter from him saying that he had moved. I think it was to Acklands. Okay, the notice to redeem, the mortgage document. One portion of the mortgage document, it referred to a time frame of 30 days. And in another section, it referred to a time frame as a month. Okay. And so there was, is it 30 days or is it a month? And so that became an issue. Okay, because some months have 28, some have 30, some have 31. Okay. So you have to make sure that your legal document, your mortgage document, your primary document of debt is tight, okay, and consistent. That the property advertised, that there's evidence of the advertisement. They can produce evidence that the property was advertised in accordance with as required by law, and the property was not properly described. Okay, so there were two weaknesses regarding the advertised property. One was evidence of advertisement, and two, the description of the property. The appraisal was something else that was called into question. They did not obtain a current appraisal at the time of the sale, and so what further complicated issues is that they had gotten an appraisal done by someone, but the person had since died, so the person couldn't be called in the court of law. So they had to get an appraisal done retroactively. Okay, so you can have an appraisal done retroactively. Okay, so they presented a retroactive appraisal that is going back in time what the property would have been worth at that time. To me, that requires a special skill. And in this case, this was the first time I've learned that you can have a retroactive appraisal. I know 3 types of appraisals, but a retroactive appraisal was something new to me. Also, there was no inventory of abandoned chattels. And as a result, because the owner claimed that there was some substantial value in his equipment that was discarded by the bank, And so the courts awarded him money based on his accounting and his inventory, because the bank did not take an inventory of the items and have them valued. Okay, and then they should have sent a letter to the mortgagor asking him to remove the items within a specified time, or that the bank, the mortgagee, would dispose of them within that within a specified time. Okay. And here's a lot of information. Here's what we know. The mortgage and further charge were dated in February 1991. The original mortgage amount was $128,000. The original further charge, we were not given that information. However, we given the total combined monthly payment was $2,640 odd. The arrears as of January 1997, that is the filing of this action, was $56,000 plus. As of January 1997, the balance owing was $58,437 odd. As of April 1998, we're told that the property was sold for $220,000 to the second and third defendants in May 1996. Okay. So there have been some discrepancies, even with the amounts owing, and as to how is it that the property was sold for $220,000? Why is it that there was a shortfall? However, it appears that the bank's debt was not fully satisfied from the sale of the commercial property, which is why it went after the residents. From the information provided, we are unable to definitively determine whether the settlement granted to Mr. McKinney by the Supreme Court was sufficient to fully satisfy his remaining outstanding debt with the Bahamas Development Bank. Okay, and that's the end of the case study. If you haven't read the case study, you'll need to read it in order to be able to connect some of those points that were made. But a whole lot of things went wrong. Their documentation, their corresponding with the client, the letter of demand, their statements contained in their letters of demand, the dates on their letters of demand, the appraisal was another fiasco. Not having evidence of advertising the property, to not properly documenting his chattels, his equipment and stuff, and there's even a dispute between who was supposed to be paying the money after he had sold to the second and third defendant, because they were supposed to be taking care of the mortgage payments, and there was a discrepancy even about that. So they were supposed to take over the mortgage payments from the rent. So a lot of it wrong with this that could have been avoided had the proper policies and procedures been put in place, and had they been followed. And even if they didn't have any in place, had they just simply followed the law and precedents, the case law, they would have come out better than they did in this case. That is the Bahamas Development Bank. Excuse me, any questions before I close out tonight's session? Again, next week we will end with module 11, and that will be it. Like I said, I will send you folks some mock or sample exam questions on these 3 modules. Although we haven't done 11 yet, I'll send for the last 3, 10, 11, and 12. and then I'll send the answers later on. Give you some chance to go through and work through the questions on your own. And again, the format for the exam, there'll be 3 sections. Sections 1 and 2, I'm responsible for. Section 3, Ms. Archer will be responsible for. For my 2 sections, the first section will be true and false questions. There'll be 25 of them. The second will be multiple choice. Again, there'll be 25. So I will comprise, my sections will comprise 50% toward the total final exam. So that's 50% of that exam. And Mrs. Archer's will be 50% of the exam.
Mr. Nordish, where's the venue for this exam?
I don't know that. Usually it's at the institute, and they based on the numbers, they may have it at different times or different days. But I'm not an employee of the administrative stuff. I mean, I could probably find out that information for you.
That's fine. As once it wasn't gonna be online home in my house. That's fine.
Well, some of them are online, but again, I don't know. COVID has changed things around a bit, and we've also changed the format of the exam. Because before, the format of the exam used to be all either multiple choice, true or false, or fill in the blank. But it is all been changed a bit. So for this cohort.
Okay.
But I'm sure you all will do well, because again, a lot of the information in the various modules, a lot of it is interconnected. So you'll see, in some cases, a lot of repetition. So when we get to, for example, when we get to module 11, those of you who haven't read it yet, module 11, you'll see, we're touching on stuff again that we've had in previous, contractual, fiduciary, professional relationships, of banker customer and whatever it is. So a lot of it is repetition. In the past, I think people have done. From my knowledge, everyone has done fairly well. I don't see any reason why it should be any different for you guys. Okay, if there are no more questions or comments, that's it for tonight until next week, which is final. So good night.
Good night.
Good night,
Mr.
sir.
Nottage. Good night.